Hello, welcome to the Sriram IAS Unacademy platform. I am Venkatesan. Today we will discuss the important topic of judiciary. We will deal with appointment of judges to the Supreme Court and High Courts and the process of removal as specified in the Constitution. Appointment of judges. As you know, Supreme Court in India originally consisted of just 7 judges in the beginning. Chief Justice and 7, including Chief Justice, there were just 7 judges in the beginning. Slowly it expanded and today we have 34 judges including the Chief Justice of India. Now the process of appointment of judges to the to the apex court is written down in the Constitution, in terms of eligibility criteria and the suitability, how they are chosen, how they are supposed to be chosen, and how they are actually chosen. This is an important aspect to discuss. In the Supreme Court, you have 3 kinds of criteria, the eligibility criteria. The first, it says any advocate who practiced 10 years of practice is eligible. And the second criterion is any judge who has completed 5 years in High Court is eligible. And the third criterion is any legal expert, an eminent person, eminent jurist who is considered to be eligible for appointment to the Supreme Court. But if you find the experience of these years after the Constitution came into force, you find that it is only the judges who had completed more than 5 or 10 years of judgeship in the High Courts, they have been found eligible for appointment as the Supreme Court judges. It's only very rarely we find that advocates who had practiced 10 years in Supreme Court or High Courts, they have been found eligible for direct appointment to the Supreme Court. So you have Justice Sikri, S.M. Sikri, who got elevated from the bar directly in the 70s, and after that, in recent years, we find that Justice Rohinton Foley Nariman was elevated from the bar, and we also have Justice P.S. Narasimha now on the bench. We also had the recent experience of the former Chief Justice of India, U. Lalit, was elevated from the bar directly. Incidentally, Justice S.M. Sikri, who was the Chief Justice in the 70s, who was the Chief Justice of the Supreme Court when the well-known Keshavananda Bharati judgment was delivered by 13-judge bench, was also elevated from the bar. So now the thing is, why is it that very few judges are elevated from the bar directly, and those who are elevated from the High Courts after having completed the minimum number of years of judgeship? Now the thing is, you have a vast pool of High Court judges. There are 24 High Courts in the country, and the sanction strength of High Courts is something around 1,000 posts, 1,000 judges. Now at any given point of time, the vacancies in the High Courts range between 300 to 400, or maybe slightly more than 400. Now, how are these judges appointed? So the Constitution says, Article 124 of the Constitution says, judges are appointed in consultation between the President and the Chief Justice of India. But this is not as simple as it is written in the Constitution, because over the period of time, there have been quite a number of changes, and these changes have got, have been concretized in terms of procedural norms of consultation. What exactly is consultation? Does consultation mean concurrence or mere consultation? Is the consultation binding on on the parties who are consulted, or the person who is consulting. I mean, these are certain issues which came to the Supreme Court in the 1980s and 90s. You have the first judge's case in 1982, which was decided by 7 judges bench in the Supreme Court. The first judge's case called S.P. Gupta versus Sriram, India. See, in S.P. Gupta, it was written that the judges held that the center has primacy over appointments. So the word consultation written in Article 24 was interpreted in such a way that the President is bound to consult the Chief Justice of India, but the advice rendered by the Chief Justice of India was not binding on the government of the day. Government had primacy. That was the outcome of the first judge's case. Now, 1981, again, that there was a lot of developments, debate, and criticism of the judgment, and in practice, had given rise to new issues, and which we find that in second judge's case, the Supreme Court came to the view, no, the primacy, if you strictly go by the debates of the Constituent Assembly at the time of finalization of the Constitution, the primacy should remain with the Chief Justice of India. So, it is the Chief Justice of India and his brother judges who know the judges much better than the executive. Therefore, the primacy should remain with the Supreme Court, with the judiciary, as represented by the Chief Justice of India and his brother judges, the Supreme Court. So, they said, well, as in any kind of decision making, if a decision making authority is just one person, it is prone to misuse. So, therefore, it's natural that if Chief Justice of India is alone having the power to decide who should be the judges, this power may be exercised arbitrarily. Therefore, the Supreme Court in the second judge's case said that this power should be broad-based. The power of recommendation to the President should be broad-based. So, Chief Justice of India in his individual capacity may have a view, but that alone does not constitute the opinion of the Chief Justice of India, because the Chief Justice of India forms his opinion in consultation with the brother judges. So, there came to exist the collegium. The collegium initially consisted of Chief Justice of India and 2 senior most judges of the Supreme Court, and in the third judge's case, it's another story, in 1999, the Government of India had doubts about the judgment delivered in the second judge's case, and because of certain issues which had come up with the then Chief Justice of India, Justice M. Punchi, and therefore the Supreme Court, in order to answer the questions posed by the President under Article 143 of the Constitution, which is advisory opinion of the Supreme Court, which was sought by the President. Again, a 9 judges bench was constituted to go into that, and then they said increase the strength of the collegium from 3 to 5. So, they said for Supreme Court appointments, there will be a collegium of 5 judges, Chief Justice of India, plus 4 senior most judges of the Supreme Court. So, they constitute the broader collegium for Supreme Court appointments. So, this collegium was supposed to consult the other judges who hail from a particular state. If a particular candidate hailing from that home state was being considered for appointment, so the judges who are already in the Supreme Court, their views were sought in writing for the sake of record, and based on that, the 5-member collegium deliberated and recommended to the government, and that advice was binding on the government. So, what happens if the government doesn't agree with a particular recommendation? So, the second judge's case and third judge's case, they visualized all sorts of possibilities, and then they said, well, if the government of the day doesn't agree with a particular recommendation, then the government can return, the president can return. The president's power is exercised, in terms of aid and advice of the Council of Ministers. The Council of Ministers will return the recommendation for reconsideration by the Collegium, and if the Collegium, on reconsideration of that recommendation, reiterates that recommendation becomes binding on the government. This was the broad terms of procedure laid down in the second judge's case and third judge's case in order to govern the appointment of judges to the Supreme Court. For the High Court, there was a different collegium in the High Court. High Court collegium consisted of Chief Justice and two senior-most judges of the High Court, and in consultation, they, informally, they had assessed the quality and conduct of the arguing counsel before them, and then they recommended a few names among the advocates or from the subordinate judiciary. Okay, these names were forwarded to the state government, state cabinet, and then after their due verification of, there are two sorts of checking and cross-checking which happens at this stage. One is the examination of the judicial acumen of the proposed candidates, whether it is Supreme Court or High Courts. The judicial acumen of the candidates, proposed candidates, is examined at the collegium level, right? The collegium, if in the case of Supreme Court, the collegium takes into account the judgments delivered by the High Court judges, whether High Court Chief Justice or judges who might have, completed a certain number of years as judges. The Constitution says the minimum number of years is 5 judges. So once there will be lots of judges who had completed 5 years. So all of them are eligible. But there is a distinction between eligibility and suitability. Eligibility is what? The number of years, the age, etc., as laid out in the Constitution. But beyond that, the collegium considers the suitability. How does the collegium assess the suitability of a candidate? By looking at the number of judgments delivered by a particular judge and the number of the quality of the judgments, not only the quantity, the quality. Whether the particular judge has delivered judgments which are in tune with the spirit of the Constitution, not only the letter but the spirit of the Constitution. So these are certain broad considerations which the collegium ought to take into consideration, but in practice it doesn't happen like that, because there are informal factors which go into the decision making of the collegium. What are the informal factors? If you look at the Supreme Court is not just merit which counts, seniority on the All India scale. Who are the High Court judges, Chief Justices who are senior in terms of date of joining of the court, not just age, date of joining, date of initial appointment as the additional judge. That is taken into consideration to determine the seniority of a judge. So there is an All India list of judges. So there is a seniority list in terms of date of joining, date of appointment as an additional judge, and once the seniority criterion is fulfilled, the other criterion comes into play. What are the other criteria? The criteria relates to geographical representation. You can't have 10 judges from Delhi out of 34. So you have only 3 or 4 judges from Delhi. So even if there are meritorious candidates from Delhi, you need to accommodate judges from other regions, because it is the Supreme Court of India, not just Supreme Court of Delhi. So if it is if you have to accommodate other regions, you have almost 28 states and union territories. So you have, if you take the Supreme Court of India now, you have among the 34 judges, you have representation for only for 17 states. What about other states? They have to wait for their turn. That is it. So the Chief Justice of India, the Collegium, whenever they deliberate about the proposed candidates, they take into account not just seniority, but the geographical representation. So it's not geographical representation which matters, it is also about the other factors like religious identity. You can't have all 34 judges from one community. You have to give representation to minorities, also to gender. So if you find that in the Supreme Court, the representation of women started very late. Even now, the representation is very negligible to women. So you have to balance all these factors while recommending names to the president. So it's not just seniority, it's not just geographical representation, it's not just gender, but representation of scheduled caste, scheduled tribes, backward classes. The diversity of the country has to be reflected in the composition of the Supreme Court in order to carry credibility to the entire population. So this is one aspect. In the high courts, you have a different criteria coming into play. It may not be geographical diversity, but social diversity, gender diversity, all these have to be taken into account while the High Court Collegium recommends candidates. Now the question is, in 2015, you had the Supreme Court judgment in the NJSC case. What does that NJSC case say? The union government at that time wanted to bring in National Judicial Appointments Commission, NJAC, as an alternative to the existing collegium system of appointments. So what is the composition of the NJAC? NJAC composed of 6 members, the Chief Justice of India and 2 senior judges of the Supreme Court, the Law Minister and 2 eminent members. Now it was challenged like everything else before the Supreme Court. The Supreme Court set up a constitutional bench to consider the matter, and their verdict 4:1. There was one dissent by Justice Chalameshwar, and the remaining 4 judges said no to NJSC because they found it unconstitutional and in contravention of the basic structure of the Constitution. Why? Because one of the basic features of the Constitution is independence of the judiciary. They felt that NJSC seriously compromised with the independence of the judiciary. How did it compromise? It compromised because by suggesting that there have to be 2 eminent members, right? If these 2 eminent members can be chosen by the executive. So these 2 eminent members can veto the opinion of the 3 members from judiciary. So that way the primacy given to the judiciary, the consultation envisaged in the Constitution at the time of Constituent Assembly debates, this was supposed to be compromised, eliminated. So the judges said no. So they revived the collegium system by their order, and they also gave a separate judgment dealing with reformation of the collegium system. But we will come to that a little later. In the sense, it's a continuing story because collegium system had its own problems. Because it was a small body and its deliberations were opaque, and many people did not know what did they decide, how did they decide, how did they choose, what are the informal factors. All this were debated in the media, and slowly the collegium understood the importance of transparency, and the transparency was meant to be achieved through making public the resolutions of the collegium. Whenever they recommended judges for appointment, the recommendations were uploaded in the Supreme Court's website so that everyone can see who was being recommended. But the transparency was not enough. In the sense, many people said, okay, transparency is fine, but it's very limited transparency which is not serving its purpose, because it's not enough if one knows the names of the judges being recommended, but we should also have details of that judge, particular candidate, the proposed appointees, so that what did they do when he or she was an advocate or as a judge, what sort of judgments they delivered. These have to be in the public domain, and these have to be discussed instead of being hurried up. What happens once the recommendation is made? The union government, already completed the checking of the personal antecedents of the proposed appointees, and then they go ahead with appointments without waiting for a public debate about the pros and cons of the proposed appointees. So this is unlike what happens in the United States, where the judges' appointments are debated and discussed in the representative houses, whereas here, everything is done discreetly, and then the public comes to know only when at the time of notification of an appointment of the judge. So this is broadly the framework with which the appointment of judges happens in India. So you have the question of Article 129. What is Article 129? Article 129 says Supreme Court is a court of record, and it also says that it can exercise all the powers of contempt. You have contempt of court separately, but the Supreme Court also derives its power to punish somebody for contempt under Article 129, which is inherent power. It's called inherent power because the Supreme Court can punish anyone on its own perception, suo motu, without anyone bringing it to the notice. There is an allegation that the person has committed contempt of court. So on its own, the Supreme Court can go through the posts on social media, and if there is a Twitter post which alleges certain thing about a judge of the Supreme Court, the Supreme Court can issue notice and ask for explanation. This is what happened in the Prashant Bhushan case during the pandemic. As we all know, that Prashant Bhushan, advocate in the Supreme Court, he was fined ultimately for the contempt of court by asking to pay 1 rupee as a penalty. Now, removal. How is a judge removed? A judge either quits by resignation or by proved misconduct, misbehavior or misconduct. Now, the word proved is very important. So, unless a misbehavior or misconduct is proved, a judge cannot be removed before the expiry of the term. So, how is the allegation of misconduct proved? So, in the case of Supreme Court judges, High Court judges, what happens is that there is a prescribed procedure. The majority of members and 2/3 members of those present and voting. This memorandum has to be presented to the president and ultimately removed. But before this memorandum is presented, there has to be a finding of guilt by a committee under the Judges Enquiry Act. A committee is set up by the presiding officer of Lok Sabha or the Rajya Sabha, and the 3-member committee goes into the allegations, gives an opportunity to the judge concerned to present his or her point of view, to defend herself or himself, and then a recommendation is made. This recommendation, whether the judge is guilty or not, is considered by Parliament, and then a memorandum is presented to the President for the removal of the judge. It's a very laborious process. Why it is necessary? Because independence of judges is one of the basic features of the Constitution, and it should not be easier to remove the judge from office, because otherwise executive will be tempted to remove judges who are not inclined to follow the ruling party's dictates. Therefore, there has to be an element of separation of power between judiciary and executive, and this is implicit in the laborious process of removal that is enshrined in the Constitution. Thank you.